And may it please the court. My name is Russell Petty, and I'm representing the plaintiff and appellant, Dr. Gordon Osborne. I don't think that there's any serious dispute that by the time he filed his disability claim, it would have been extremely risky to Dr. Gordon's health for him to attempt to resume practice as an oral surgeon, and is typically the case in disability cases. There are a number of factors that go into creating that danger. One of them is, of course, the COVID pandemic. A second factor is Dr. Osborne's pre-existing conditions, his hypogamma, the immune deficiency, and his chronic asthma.
Well, didn't he say that if he had gotten the PPE equipment, he would have been happy to reopen? Well,
you know, there are 3 or 4 responses to that, and let me sort of walk down them. One of them is that, you know, that statement was directly related to the period of time in May of 2020, which is prior to Dr. Osborne suffering his pulmonary embolism, and it's, 5-6 months before he actually decided to file a claim for disability benefits. That's argument point number 1. Point number 2, remember, this is a summary judgment case, and we've got a statement by Dr. Dougherty, a medical professional, who states that the Dr. Osborne was disabled at that point. And in addition, Your Honor, I think that people didn't necessarily appreciate the risks of the pandemic when it first happened. I remember in late February of 2020, I had a status conference in front of Judge Dean Pregerson. It was all very informal. We were in chambers. We were all talking about this COVID. He asked me what I thought of it, and I says, Your Honor, it's the flu with better public relations. That's what people thought, and the realization as to how serious the COVID was going to be, and the risks to the health that was going to occur.
Mr. Petty,
yes.
I need you to help me with some timeline issues that are a little fuzzy to me. Did Dr. Osborne's doctors recommend that he discontinue his practice?
Yes, Your Honor.
And when was that?
Dr. Couchu, his immunologist, stated, she testified at deposition, that she told all her patients with hypogamma, the compromised immune system, that they should stay home during the pandemic.
But now he did not remember that.
He did not remember that, and that's also not in her notes. But she did testify at deposition that that's what she told everybody.
Is it sufficient, even on a summary judgment standard, where she says, well, I told everyone this, but I don't have any notes of telling this specific person, and this specific person doesn't have any recollection of me telling him?
Well, Your Honor, I think it is, especially because Dr. Dougherty also said at deposition that he told Dr. Osborne something along the lines of, people can make their own decisions, but you've got bad lungs and you're high risk.
And Mr. Petty, I'm sorry, I still need an answer to mine. When was that? What month? What?
No, that would have been the day before Dr. Osborne closed his office. So that would have been in March of 2020.
Okay.
At any rate, and the fixation that the court below had on, he's got to be told before he goes out on disability. I mean, I've done hundreds of these cases. That's typically not the case. Typically, the case is that the claimant decides he can't work anymore and leaves work.
Well, forgive me, but I appreciate your experience, but it's not part of the record of this case, is it? Your experience?
No, I'm sorry, Your Honor. No, my experience is not part of the record, but I do think that I can say that it's typical for the doctor to weigh in on whether somebody is disabled after the fact. I don't think there's any legal requirement, certainly no policy requirement, that the physician weigh in, prior to somebody leaving office. I think that's sort of fixating on that, I think, takes us away from the real issue, which is what the doctor's opinions are. And we've got two physicians here whose opinions are that Dr. Osborne was disabled because of his high-risk situation in
Was it just the high-risk situation, or was it high-risk situation and inability to get PPE?
Well, so sort of you're working back into to where I started, Your Honor. I mean, there's the fact that he's high risk. His conditions would have made it more likely for him to contract COVID and make it more serious if he did contract it. Later on, he had a pulmonary embolism that adds to the danger.
After the pulmonary embolism is the argument, your client's argument, that even with PPE, it then wasn't safe for him to continue his business practice? Is that
Well, I don't think it was ever safe for him to continue in his business practice. And Judge Seaborg, in the Downs case, specifically addressed the issue. Unum argued, well, this pediatrician could have protected herself with PPE, and Judge Seaborg cited to medical studies standing for the proposition that no, PPE might help you a little bit, but it's not, full armor against this.
Okay, so really with or without it, starting in March,
Yeah.
the argument is that he was totally disabled.
But at any rate, and also when you consider the risk factors, Your Honor, I mean, it's working as an oral surgeon you're working in close proximity to patients' unmasked mouths with a cloud of aerosol cloud of the patient's blood and saliva. It is truly very risky, and the failure to get PPE. And the point is that which of those factors is more important? The relation of those factors to another. Would he? If you pulled one out, I mean, that's an extremely factual issue.
Mr. Petty,
Yes.
explain to me. I'm trying to get this timeline in my head. So Dr. Osborne chose to close his practice in June of 2020 because he could not obtain adequate PPE. Is that correct? At that point,
Yes.
He thought, if I get adequate PPE, I'm going to keep working.
That is correct, Your Honor.
Okay. And it wasn't until August when he had the pulmonary embolism. Now, at that point, was he explicitly told, and does he remember he was told, you shouldn't work anymore?
I don't think that he had any conversations. I mean, he wasn't working. There's really no reason to, for a doctor to say, you should stop working when he hasn't worked for some time. So no, there's nothing in the record, and I doubt, frankly, that there was anything in the record.
And then it's my understanding that he was able to start getting, more consistent, I guess, PPE in August. Is that correct?
No, Your Honor.
Okay, explain.
Ms. Craven testified that she had attempted back in March to obtain a variety of PPE, masks, booties, gowns, gloves, face shields. She testified at deposition that sometime in either late July or early August, she had received some masks, but there's no evidence that the full suite of PPE, which was necessary to protect a dentist working in that environment, was ever available at any time in the record. And so that's really one of the factual errors that the district court made.
And let me just make sure I understood you earlier. Did you earlier state that even if he had everything, all the PPE, given his pre-existing conditions, he still should not or would not have returned to work or should not have been working?
Yeah, the risks were too high. And I note that Dr. Dougherty, in his conversation with Unum's Dr. Anticky, told him, look, he was disabled, and even if he wanted to go back to work, he shouldn't have gone back to work. And he was
Can I shift
explicit
gears
about
for a second to your claim under the BOE policy? I understand how you might have a claim until mid-June when he finally closed his office, but not after that. What's the basis for the claim after he fully closed down the office?
Well, you still have expenses that relate to shutting down his business even after the business physically closes. And when you think about it, Your Honor, I mean, the purpose of purchasing the business overhead coverage is to to pay bills like that in the event you become disabled. And the notion that, well, you're disabled and so therefore your expenses aren't going to be covered sort of defeats the purpose of having that. In the Uno case, which applied to Oregon law, the physician closed his practice and continued to do some collections and respond to to inquiries, but was no longer treating patients. But closed his medical practice, and the court held that those were still recoverable expenses under the BOE policy because it defined operation broadly. I mean, the judge's below decision turned on the definition of operation of your business being the treating of patients. Operation of your business is not defined in the policy. Under California law, that term should be defined broadly in order to meet the reasonable expectations of the insured. And so as long as it's a regular operation that's necessary to carry on the business, it should be covered.
What were the regular operations that were happening after your client stopped seeing patients? What?
There were some collection activities. There were some responding to patient inquiries, responding to inquiries from other
But wasn't that all in the period between March and June?
I suspect, Your Honor, that the great bulk of the expenses we're talking about were incurred during that period.
Okay.
I think you're right about that. I think there actually. I'm not sure there were any invoices for that were submitted.
And so even though we're here on summary judgment, if there was nothing in the record indicating any expenses after mid-June or so, then your adversary would be entitled to summary judgment for that period after that, yes?
Well, I mean, the summary judgment was granted over the period from March through June.
I'm saying...
We understand.
But assuming that we were to agree with you on the period from March to June, is there anything in the record that shows any expenses being incurred after mid-June?
Your Honor, I would just have to look at that. I mean, there's several hundred pages of invoices. As I stand here, I can't recall any of them being generated after June when the office was actually closed. But I just can't say that with any certainty. It's just not an issue that arose below, and so I just till the court pointed it out, I'd never really considered that.
Counsel, I don't want to cut into your time too much, but I do want to ask you about Paul Revere versus Ward. Are you familiar with that case?
I lost that case at the Ninth Circuit, Your Honor.
Okay. Then why shouldn't we treat it the same?
I'm sorry, Your Honor, I don't understand the question.
Why shouldn't we treat Dr. Osborne the same way, his case the same way that we treated Paul Revere versus Ward?
Oh, I'm sorry, Your Honor. I'm thinking of a different case. I'm not familiar with Paul Revere versus Ward.
Okay.
I'm thinking of Unum versus Ward.
Okay. Thank you.
Oh, I'm sorry.
I thought you were going to say that because you lost once in the Ninth Circuit, we should be fair and rule for you this time.
That would be a wonderful result, Your Honor. I'm sorry. The court's question is?
So Paul Revere versus Ward was a case where a plaintiff was an attorney. The attorney was being looked at for ethical violation, so he voluntarily stopped practicing.
Yes, I'm sorry. That case is in the record. Well, the legal disability cases they all have one thing in common. Ward is one of them, and I'm sorry, I should have recognized the case. Ward is one of them because all of those insureds are suffering from some legal reason why they can't continue to do their work. In Ward's case, it was because of his legal problems. Dr. Osborne here has no legal problems. Those cases are all inapplicable because they only apply to people who have some legal infirmity that prevent them from working. I will reserve, if there's no further questions, I'd like to reserve the minute I have remaining.
Okay, yeah, I'll put 2 minutes on the clock for your rebuttal.
Thank you, Your Honor.
Thank you.
Good morning again, Your Honors.
Morning.
May it please the Court, I'm Dan McGuire, here to represent Paul Revere. We would respectfully request that the Court affirm the lower court judgment because all material facts are undisputed and the District Court properly interpreted the contract as a matter of law.
So the district court based its decision on part on, quote, no doctor recommended that Dr. Osborne stop work. But isn't that belied by the record?
No, Your Honor.
Well, there was testimony that was just referred to about how one of the physicians said she recommended to all her patients they stop work in this situation. He didn't expressly remember that, but that doesn't mean if the jury credited her testimony and applied it to him that there wasn't a jury issue, was there?
There was no jury issue, and here's why, Your Honor. This is Dr. Kotru, and she is the immunologist. So he saw Dr. Kotru on March 8th. He continued to work full-time before, during, and after that visit. Dr. Kotru's notes don't contain any restrictions or limitations. In fact, his conditions were under control. Dr. Kotru's advice that you just reiterated was general advice given to all her patients, which basically amounted to be safe out there. And if you need a note for your employer, please come back and see me and I'll give you one. Here it's interesting to note that Dr. Osborne didn't file a disability claim till 8 months after that, and he never went back to her to get an attending physician statement in the way that she suggested. So Dr. Osborne had practiced for decades, carrying the same diagnoses, including through the flu seasons, and I hope that answered your question, Your Honor, on Dr. Kotru, but I'd be happy to elaborate.
Well, now, wasn't there also in Paul Revere's own notes an indication that Osborne was, quote, advised not to perform dentistry and oral surgery due to COVID pandemic, close quote.
And he had no PPE, and that's really the heart of the case, Your Honor, is on a causation analysis with the policy definition of disability, the inability to work must arise from an injury or sickness. There's that causation between the injury and sickness and the reason he didn't work. And in this case, the reason he didn't work didn't have anything to do with any doctor's advice or anything else other than the dental board suggesting to its members that they restrict their treatment to emergent procedures.
I'm searching for it now, but isn't there a gloss on that under California law? So it's not quite as direct a causation issue as you're indicating. I'm sorry, I don't have that citation right in front of me, but...
Is it the definition of disability to
yes.
which Your Honor refers? May I?
Yes.
So in California, a particular part of that policy is given a certain definition by reason of the California Department of Insurance. And it means that total disability means that because of injury or sickness, the insured is unable to perform the substantial and material duties of his or her occupation with reasonable continuity in the usual and customary way. However, that part of the definition isn't what's at issue here. What's at issue here is the causative link between an injury and sickness on the one hand and the reason that Dr. Osborne is not working. If he's unable to work due to a reason other than injury or sickness, then the causation argument fails. He's got the burden of proof. He hasn't shown that. No benefits are payable.
What about after he suffered a pulmonary embolism?
At that point, this is in August now of 2020, he had already closed his practice permanently for reasons obviously unrelated to the pulmonary embolism he would later experience. But that was treated, and on August 4th of 2020, he reported into the doctor to follow up on that, and the doctor said that he was clear. And the company found that he was unable to work for a certain amount of time because of that, 27 days I believe it was. But because that didn't exceed the elimination period of 30 days, no benefits were payable. So I'm sorry, Your Honor, were you going to ask me something else?
No, go ahead.
Okay. So the material factual question really just comes down to an interpretation of the contract. It's an issue of causation. And the question is, why did Dr. Osborne stop working? If the reason he stopped working was because he was injured or sick and he couldn't do it, then that's what this policy pays benefits for. But if the answer is he left work and didn't return to work because of a reason other than injury or sickness, then there's no benefits payable because there's no factual disability.
So, but my understanding, correct me if I'm wrong, is it's sort of in between here, because he had, even before the pulmonary problem, he had a medical condition that made him so susceptible to death if he contracted COVID that he was advised not to take a risk, at least not without getting very full PPE. So wasn't it a combination of the outside situation and the inside situation?
No, Your Honor, and here's why. So we know that he had these conditions for decades. He practiced for decades full-time, before, during, and after the visit to Dr. Cottrell.
Yeah, but that was before COVID.
It was before COVID, that's right, on March 8th. So at March 8th, he leaves the office of Dr. Cottrell, and he doesn't say, well, Dr. Cottrell just told me to stop working, it's too dangerous, let's cancel all the patients. He went back to work and worked for another week's full of patients. Then, I just want to mention Dr. Doherty, since it came up in the court's questioning earlier. He saw Dr. Doherty on March 12th, and that was the last day he saw patients. But he was planning to see patients on that next Monday, March 16th, until the AAOMS had suggested that procedures be restricted to emergency procedures. That's when he came in. He told his office people, cancel all the patients, that we don't have any PPE, we can't do it safely. And now Dr. Doherty first opines that Dr. Osborne is unable to work as of March. When? In November. So it's a hindsight analysis. He's had 2 office visits at least since then, between the time he left work and the time he signs the attending physician statement. Neither of them refer to any advice that he stop work. And then he's going to sign an APS to essentially rewrite history and say he couldn't work since March. Well, why didn't you tell him that? And if you did, why didn't you put it in your notes?
But these all sound like disputes that could be decided at trial. I'm not sure that any of what you're saying means that summary judgment is appropriate. I guess, is your argument essentially that because he went back to work after the Dr. Cottrell appointment, that as a matter of law, basically, she could not have told him to stop working at that point in time? He couldn't have been thinking about it, debating about it, trying to figure out what to do?
Well, the answer to Your Honor's question is it was proper for summary judgment because there's no dispute that the reason he left work had nothing to do with anything Dr. Cottrell or any other doctor said. Instead, it had to do with advice given to him by the dental board. And the reason he didn't return to work was because he couldn't get the PPE. So the advice by the dental board to restrict to emergent procedures is not an injury or sickness. The inability to get PPE due to a supply chain issue is not an injury or sickness. When he decided to close the business permanently 3 months after he first left work, sell his house, move away, try to sell his equipment, that was not an injury or sickness. That was a self-created barrier to returning to work.
Because at that point, he can get PPE. At this later point.
Right. So whether he actually got the PPE in June, July, August, September, I mean, it doesn't really matter. It's not a material fact because the reason he didn't work was because he couldn't get the PPE, and the reason he closed was because he didn't know when he could get it.
So, counsel, what is the expectation then for Dr. Osborne, given that you're saying, look, not being able to get the PPE and being in a pandemic is not enough because it's not injury and it's not sickness. So should he have been risking they were pretty certain. Everybody was pretty clear about the fact that given his hypogamma, he was very susceptible to getting very sick if he contracted COVID. So what is someone in his position to do to be able to get coverage and be safe?
He gets coverage under this kind of policy if he's injured or sick, and that causes him not to work. If there's a pandemic, if the building burns down, if there's a mold infestation in the building, those are all reasons why he can't go to work either. But those are not risks that the policy insured against. To answer your COVID question, The remedy is to do it exactly what he did, to play it safe, to be careful. He went into the office every day. It wasn't like he was afraid to get out of the house. But then he submitted an application for a PPP loan, like many businesses did at the time, and then he submitted an application for to waive, or I forgot the word, but to forgive. That loan. So that was what the situation was that presented itself.
Assuming for the sake of argument that we thought there was a jury question under the first policy, where does that leave the second policy?
So the causation issue would apply to both policies, and Your Honor's question is...
Right. I'm saying, assuming arguendo, we think the causation issue was not sufficiently resolvable on summary judgment.
If the court were to reach that issue, then the analysis is whether covered monthly expenses are payable. Covered monthly expenses are ordinary and necessary in the operation of the business. The business was treating patients. He had treated no patients since March 12 of 2020. The case law says that winding up expenses is not running an office. Operation means ongoing. His people were with him for years. Did he want to cut them loose and send them on the street? No. Was that commendable? Yes. Was it an operation of his business? No. Their job was administrative in nature. Keep the patients informed when they call in, apply for the PPP loan, and do the administrative aspects of the office. I see I have 3 minutes left. I'm not going to give them to Mr. Petty, but but I will please invite any of the three, Your Honors, to ask me any questions you might have so that I can direct my comments to any concerns.
Do you have any other questions, Judge Alma? Judge Rakoff, any other questions?
No.
I don't think we have any other questions for you. If there's anything else you'd like to tell us, you've got 3 minutes left. Otherwise, we'll happily accept the time back.
Okay, well, I'll take one of the three.
Perfect.
We'll compromise on that. So in conclusion, we would respectfully request, Your Honors, to uphold and affirm the lower court's judgment for the following reasons. Plaintiff has the burden of proof that he's unable to work because of injury or sickness. It's a causation analysis. The reason he left work was because of advice he received from the dental board, not an injury or sickness. The reason he didn't return 2 to 3 months after that was because the PPE supply chain was interrupted. Supply chain interruption is not an injury or sickness. The reason he didn't return to work after the end of May or beginning of June was because he voluntarily walked away, in his own words, from the practice. Voluntary closure of a business is not an injury or sickness. So because under those facts, which are undisputed, appellant fails the causation test, no benefits are payable, and we would request respectfully, Your Honors, affirm.
Thank you very much.
Thank you.
First, thank you, Your Honors. First, Judge Thomas, was exactly correct. When she pointed out that Mr. McGuire's very excellent argument was really more like a jury argument than it was anything else. We have a summary judgment case that Dr. Osborne was not medically disabled, in spite of the fact that we've got 2 physicians who state very clearly that they believe that he was disabled because of his medical condition, pulmonary embolism, the immune deficiency, and the chronic asthma. And so, the reasons when asked, why is this still a summary judgment case? It's, he accused Judge Dougherty of rewriting history when he stated very firmly in the attending physician statement in November that he believed that Dr. Osborne was disabled because of his medical condition, and I submit that is a jury question, which should have gone to the jury and should not be decided on summary judgment. I'm going to raise an issue which isn't in my papers. It's sort of occurred to me later. We I spoke at the beginning of my argument as to how there are a number of factors involved and which is more important than the other. If you look at
Can I go back just 1 second to the Doherty issue? And I'm sorry that I don't have the citation to the record. Tell me exactly what he said or recorded in his notes.
If you're talking about his November 2020 notice,
yes,
he said that that due to, well, I have the well, what he basically said, patient advised, this is in the record at 2 ER 262, patient advised not to perform dentistry or oral surgery due to COVID pandemic. He is a high-risk individual due to age and labial extrinsic asthma.
And just so I'm clear, that is a statement of what he said then or what he said earlier?
That is what he wrote in the in November of 2020. What he testified that he told Dr. Osborne back in the time is, I'm not going to make any decisions for you, but you've got bad lungs and you're high risk.
All right.
That was his testimony of what he said. Can I have 30 seconds just to make that?
Just take, yeah, you can take 20 more seconds. Go ahead. Thank you.
The AD&D policies, and this court has addressed those in numerous cases, they're triggered by an accident, and they all have language excluding other causes from the accident. The accident has got to be the sole cause of the injury. If Paul Revere wanted to have this policy where the sickness or injury is the sole cause and we shouldn't look at external factors, they should write that into the policy. They failed to do that, and Paul Revere is attempting to have this court write an exclusion for a policy when that exclusion is not in the policy itself.
Okay.
If there are any further questions, I'm happy to take them. I appreciate the court's indulgence in letting me run a little over. Thank you.
All right. Thank you. Thank you very much, Mr. Petty. Thank you, Mr. McGuire, for your helpful arguments this morning. This case is submitted, and we are adjourned for the day. Thank you.
Thank you, Your Honor.